Imagine this: someone commits a violent act, say an assault or even a homicide. They're arrested, charged, and brought to court. But something's different. They seem confused. They talk about voices. They say they were protecting themselves from a government satellite. Suddenly, the conversation shifts, not just about what they did, but whether they even understood it. This is where mental health collides with criminal responsibility. In this video, I want to walk you through one of the most controversial questions in law and psychiatry. Can mental illness excuse a crime? What does it mean to be legally insane? How do courts decide if someone was responsible for what they did? And where do we draw the line between sickness and culpability? Let's take a deep dive, assessing into the mind, the law, and the gray areas in between. What is criminal responsibility? At its core, criminal responsibility means this: a person can be held legally accountable for a crime if they committed the act and understood that it was wrong. This seems simple, but it depends on two key components. One, actus reus, the guilty act. Did the person commit the physical act of the crime? Two, mens rea, the guilty mind. Did they do it intentionally, knowingly, and with criminal intent? Now here's the twist: mental illness can interfere with both. It can cloud a person's awareness, distort their judgment, or even break their connection with reality altogether. And in such cases, the law must ask, did the person's mental state at the time of the crime make them legally not responsible? The insanity defense. This leads us to the concept most people know, but few truly understand: the insanity defense. Let's be clear: this is a legal determination, not a medical one. You can be mentally ill, even severely, and still be legally responsible for your actions. To be found not guilty by reason of insanity, NGRI, a person must meet specific criteria. Legal tests for insanity. Different jurisdictions use different tests, but here are the most common. The Manhattan Rule, most widely used. To qualify as legally insane, the defendant must have a severe mental disease or defect that made them unable to understand the nature and quality of their act, or unable to know that what they were doing was wrong. The Model Penal Code test. Used in some states, this test is a bit broader. A person is not responsible if, due to mental illness, they lacked substantial capacity to either appreciate the criminality, wrongfulness of their conduct, or conform their behavior to the law. This includes impaired control, not just impaired understanding. No insanity defense. Some states like Idaho, Kansas, Montana, and Utah have abolished the traditional insanity defense altogether. Defendants there can still raise diminished capacity or lack of intent, but cannot plead NGRI. What mental illnesses are relevant? Now you might be wondering, what kind of conditions are we talking about? The most common diagnoses seen in insanity defense cases are schizophrenia, especially with paranoid delusions or command hallucinations, bipolar disorder, during manic or psychotic episodes, severe major depression with psychotic features, delusional disorder, dementia, or brain injury, affecting reality testing, substance-induced psychosis, though often excluded. Important point: personality disorders like antisocial or borderline generally do not qualify for the insanity defense. Why? Because they don't typically involve a loss of reality or morality. Examples of impaired criminal responsibility. Let's look at some real-world examples. Example: clear case of legal insanity. A man with paranoid schizophrenia believes his neighbor is a demon trying to poison him. He hears voices commanding him to defend himself. He kills the neighbor in what he believes is self-defense. He is psychotic, unable to grasp reality, and unaware that the act was morally or legally wrong. He may be found not guilty by reason of insanity. Example: mentally ill but legally guilty. A man with bipolar disorder robs a store while manic. He knows it's illegal. He plans it in advance. He just feels invincible. Though ill, he understood his actions and their wrongfulness. He is mentally ill but criminally responsible. How psychiatrists evaluate criminal responsibility. This is the domain of forensic psychiatry. When courts ask, was this person insane at the time of the offense? Psychiatrists are brought in to help answer. Here's how the process works. 1. Record review. Medical history, police reports, witness statements, video footage, past psychiatric evaluations, everything is examined. 2. Interview with the defendant. Often, multiple interviews are conducted to assess mental status, psychotic symptoms, memory of the event insight, motivation, truthfulness. 3. Collateral information. Family, friends, jail staff, or therapists are interviewed to understand how the person was behaving before and after the crime. 4. Psychological testing. Some evaluations use tools like MMPI or malingering tests to detect exaggeration or deception. 5. Forming the opinion. The psychiatrist ultimately offers an opinion. Did the person suffer from a qualifying mental illness? Was that illness active at the time of the crime? Did it impair their understanding of the act or its wrongfulness? This opinion can influence the judge, the jury, or plea negotiations. Misconceptions about the insanity defense. Let's clear up some common myths. Myth 1. The insanity defense is common fact. It's used in less than 1% of felony cases and only successful in a fraction of those. Myth 2. It's a get out of jail free card. Fact. People found NGRI are usually committed to secure forensic hospitals for years, often longer than a prison sentence. Myth 3. Any mental illness qualifies fact. Only severe conditions that impair cognition or judgment qualify. What happens after an NGRI verdict? If someone is found not guilty by reason of insanity, they are not released. They are usually committed to a secure psychiatric facility, treated until they are no longer considered dangerous, reviewed regularly by forensic review boards, only discharged when deemed safe by clinical and legal authorities. Some stay for months, some stay for decades, some never leave. Diminished capacity versus insanity. There's a related but separate concept called diminished capacity. This applies when the defendant was mentally ill, but not legally insane. Their illness reduced their intent or impulse control. In some jurisdictions, this can reduce a murder charge to manslaughter, for example. It doesn't excuse the crime, but it may mitigate it. Moral and ethical questions. This topic raises deep philosophical and moral questions. Should we punish someone who didn't understand their actions? Can we ever truly know what was in someone's mind at the moment of the crime? What's the difference between badness and madness? These are questions the legal system must wrestle with, and psychiatrists must inform. It's not about sympathy or excuses, it's about justice, safety, and truth. Final thoughts. Mental illness doesn't always erase responsibility, but in rare, serious cases, it can undermine the foundation of legal guilt. That's why courts bring in psychiatric experts to shine light on the invisible and help society decide when the law should punish and when it should treat. This isn't about letting people off the hook. It's about understanding the mind and upholding justice with integrity. Because in the end, how we treat the mentally ill, even when they commit crimes, says everything about the soul of our justice system. If this video helped you understand how mental health affects criminal responsibility, please like, share, and subscribe. Tell me in the comments. Do you think the insanity defense is fair? Too strict? Too loose? Let's discuss. Until next time, take care of your mind. And remember, justice is strongest when it understands the human mind, not just the crime.